What's wrong with the following sentence that a junior lawyer might include in a letter of advice to a client who was injured in a road traffic accident? Let's read it. Pursuant to the case of Jonny v. Stevenson, 1932 AC 562, the claim you have for the injuries you sustained in your recent RTA is founded in the tort of negligence, and you would bring the said claim against the driver of the motor car which crashed into your vehicle. For a forensic analysis of this piece of legal writing, as well as some top tips on the skill of legal writing for SQE2, stay tuned after the jingle.
If you wanna be solicitors, why don't you come and visit us at SQEtv?
Those of you who are regulars to SQEtv will have seen our legal drafting top tips video and the subsequent one we released that analysed the sample question and the sample answer that the SRA have provided in relation to the skill of legal drafting. We're going to do something very similar in this video and a subsequent video for the sister skill of legal writing. So in this video we're going to be focusing on the basics of what legal writing is, the difference between it and legal drafting. We'll also give you some top tips in order to go away and hopefully be able to prepare better for the assessment. And then in a subsequent video what we'll look at is the sample question on legal writing that the SRA had provided. I will attempt it myself and compare my answer to the sample answer that the SRA had provided. But that's for later. Let's now focus on the basics of legal writing, how it's assessed and what the examiners are looking for.
SQEtv.
In the link below you'll find access to the SRA's specification and also the performance indicators for legal writing. What are each of these documents? Well, the first one, the specification, deals with the black letter law and practice areas that will be examined when it comes to the skill of legal writing, but also an overview as to what the examiners are looking for. And then the performance indicators give you a much more detailed look at what competent looks like and what not yet competent looks like. So what are you looking to do to achieve to get over the line to pass a legal writing part of your SQE2 assessment? And the first thing you'll notice when you look at both of these documents is that there's a degree of overlap between the two skills themselves, legal drafting and legal writing, but they are very different skills. So what's the difference? Well, both being written skills, they have a lot in common, and we'll talk about in a moment about the fact that the ABC of legal drafting applies as much to legal writing. That's accuracy, brevity and clarity. More about that in a moment. But what legal drafting, as we know from our previous videos, is principally testing is your ability to prepare a specific legal document based on a case study where you've been given instructions and documents, and then compare that to legal writing, which is more a test of your communication skills, typically by sending an email, writing an email or a letter, or perhaps a memorandum, depending on who the recipient is. So legal drafting is more of a test of your knowledge and understanding of what you need to include in the relevant document, how you draft it, the test of your ability to convey everything that you need to from your instructions and create something that's legally comprehensive for a document of that type. Whereas legal writing is more of a test of your written communication skills. Do you know why you're writing what you're writing to that particular recipient? What are you looking to achieve? What outcome are you looking to achieve from your communication? Are you effectively communicating in a way that is going to get the person on the other end, A, to understand it, and B, to take whatever action you need them to take? And does it reflect your instructions in the context of the case study that you've actually been asked to consider as part of the assessment? So there we are, that's an overview of legal drafting and legal writing. Let's now have a look at what legal writing is and how it's assessed.
SQEtv.
So how is legal writing assessed in the SQE2 assessment? Well, just to remind you, the SQE2 assessment contains 3 written skills days, and you will be expected on most, if not all 3 of those days to perform a legal writing exercise in the context of one of the practice areas. And here's the thing, you can revise the relevant practice areas because in the specification Annex 1, it lists the FLK topics that could come up during the course of such an assessment. So check that out. The sample question on the SRA's website is one for 30 minutes, so during that time you'll be given, in that case, 2 pages worth of instructions, a document to reference as well, the sort of thing that you might look up if you were doing this sort of task during everyday practice. There's no loss of marks for spelling mistakes, that's good to say. However, they're only spelling mistakes that are ones that would be picked up by spell check. If you make a spelling error with regard to the name of somebody involved, or perhaps a figure or a date that's mentioned in the scenario, you may well be marked down on that, because that's actually a substantial error rather than just a typographical error because you spelt the TEH rather than THE. You wouldn't be penalised for the latter, but you certainly would be penalised for getting a fact wrong that's relayed to you in the scenario. One thing that you won't get penalised on is poor formatting. The examiners appreciate that actually when it comes to the platform they use, there's very little support that's given in formatting, so don't get overly concerned with how it's presented in terms of your piece of legal writing. It should be structured well, of course, but don't get overly concerned about spaces and paragraph numbers and things like that. It's more important what the substance is.
SQEtv.
When we look at the performance indicators for legal writing that the SRA have published, you'll see that there's a considerable overlap with the performance indicators for legal drafting. Look at this one. Use clear, precise and acceptable language which is appropriate to the recipient. In other words, it's the ABC of legal drafting. It's just as valid for legal writing. A, accuracy. Make sure you're accurate with regard to the facts, the dates, the names, and the law that you're putting into your piece of legal writing. B, brevity. Don't use 10 words when 1 or 2 will do. And C, clarity. Speak with language that your client is going to understand and don't be ambiguous. And on that front, make sure, as you can see from the quote in front of you, that you're using language that's appropriate to the recipient, because you'll write in language that's very different to a client as opposed to language that you'd use when you're speaking to a solicitor on the other side, or perhaps a work colleague. So always bear that in mind. There will be marks for making sure you're using the right register, the right tone with the recipient of your piece of legal writing. So, turning to our earlier example, there are at least 5 things wrong with the statement that we mentioned to you before. You can see that now on the screen. Give yourself a few minutes to spot them and then rewrite the sentence. Imagine it's part of a letter of advice in relation to a personal injury client who's seeking some advice from you on the prospects of success of their personal injury claim. That will obviously be something that might follow a road accident in the context of the fact pattern. So here it is. Pursuant to the case of Jonny v. Stevenson, 1932 AC 562, the claim you have for the injuries you sustained in your recent RTA is founded in the tort of negligence, and you would bring the said claim against the driver of the motor car which crashed into your vehicle. So just give yourself a few minutes just to spot at least 5 errors there and rewrite the sentence that would be appropriate in the way that you would deliver that message to the client as part of a letter of advice in a personal injury claim.
SQEtv.
So how did you get on? Well, I had a problem with the very first word, pursuant to. Pursuant, what sort of word is that to include in a letter to a 21st century client? It's certainly not something a 21st century lawyer should be writing in any letter to a client. Why? Well, it just sounds over pompous. It's something that belongs in a law essay, and frankly, I don't really think it should belong in a 21st century law essay either. It's over formal language and it's to be avoided. Secondly, don't cite statute, or in this case, case law, to the client. Why not? The client doesn't want to know the authority that led to your conclusion. They simply want to know where they stand, generally speaking. So avoid citations of case law and statute unless it's absolutely necessary. Thirdly, don't use jargon or abbreviations that the client may not understand. And in this letter, we've used RTA to mean road traffic accident. Now, I accept that many clients will understand what RTA stands for, but sometimes it looks a little over informal actually if you use abbreviations. And equally, how do you know your client will definitely know what that stands for? You probably don't. So try and create that balance between professionalism and being over pompous, or even pompous at all, and find that middle ground. And naturally just trust your instincts, because they'll normally be right. Fourthly, there's another over formal, over sort of pompous use of language there as well. The said claim. Again, this is something that you may have included in a law school essay, to use the said this or the said that. It really is language that belongs, frankly, in the 19th century. It's not something that a 21st century lawyer should be using in language really to anybody, apart from possibly when you address the judge in court, where the language is very conservative and very formal, and use of that language might be appropriate. But apart from that, certainly not in a letter to a client to use the words "the said this" or "the said that." The final amendment we suggest you should have found is where we use more than one word when one word will do. Can you see where that is if you didn't spot it? Well, it's right here. Just the use of the words "the motor car." Why say the motor car when you could just say the car or the vehicle? And now you might think, well, what difference does it make? Well, it's one less word. And to be honest, the fewer words you use in any communication to a client, the more effective it is likely to be. So there you go. Now, what do you think the final version of this particular example should look like? Well, here it is. And you'll be surprised that we've actually written it in less than half the words of the original. And all the client wanted to know is basically they had a claim. So this is what we come up with. You have a claim against the driver of the other vehicle for the injuries you sustained in the accident. Isn't that clear, plain English, as opposed to the nonsense, frankly, that is drafted initially by this particular candidate?
SQEtv.
So there you go. Lots of things to take on board there. I hope you've learned a lot from this legal writing exercise. And remember, we've got our sample question analysis that we'll be doing in a separate video. In the meantime, if you enjoyed this video, don't forget to tap the notification bell you can see right above me. That will mean you get to see all our videos as soon as they drop. Please do like and subscribe as well. We love it when you do. And finally, as we always do, when we finish a video at SqEtv, we say, it's now time for the jingle.
If you wanna be solicited,